Welcome back, everybody, to the OADC 2020 virtual fall seminar. Our second session today, take a closer look at navigating policy limit demands with JAMISON McCune and Peter Rigsby. Before I introduce those two presenters, I'd like to say a few words to mention another one of our sponsors, McCann Medical Evaluations, Inc. McCann provides IMEs and records reviews in Oregon and Washington here in the Pacific Northwest. You'll find their contact information on the OADC website by clicking on sponsors. Thanks to McCann for being an OADC sponsor, and thanks to all of our sponsors throughout 2020. Your support is very much appreciated. Now, on to our featured presentation, Navigating Policy Limit Demands. I'd like to introduce our presenters, JAMISON McCune, who is an associate at the BODYFELT firm, where his practice emphasizes injury and property damage claims, coverage, and commercial litigation. I understand in high school, Jamison's first job was as a looper at a local country club. And in true Caddyshack fashion, he was awarded the Evans Scholarship, a Caddy Scholarship, which allowed him full tuition at the University of Oregon. Go Ducks. Jamison graduated from the University of Oregon in 3 years with a double major in political science and philosophy. Spent many Saturdays rooting for the Ducks in the stands at Autzen Stadium or MacArthur Court. He chose to remain at Oregon for law school because of his love of the state, its proximity to the Ducks, and his desire to practice law here in the Pacific Northwest. We're fortunate to have him present today, as he's a very busy guy. He and his wife have a 9-month-old son at home. Peter Rigsby is a shareholder at BULLIVANT, and his practice includes a variety of areas of casualty commercial litigation, both state and federal court of Oregon and Washington. His practice emphasizes insurance defense, products liability, wrongful death, catastrophic injury, professional malpractice, employment litigation, and general commercial litigation. Prior to joining BULLIVANT, Peter practiced insurance defense, construction defect work, general civil litigation. He's handled complex litigation, including multi-party construction defect cases, and he worked as a former extern for a state Supreme Court justice and law clerk for 2 state court trial judges. So he's got a broad range of legal experience. A little bookkeeping reminder, your microphones and video are muted for this session. If you want to ask a question, enter it into the chat section. I'll be monitoring that and ask questions of the presenters on your behalf. With that, Jamison and Peter, take it away.
All right, thank you for that introduction, Brian. Good afternoon, everybody out there in CLE land. As noted, this presentation will discuss policy limit demands and steps you should consider taking and handling them. Jamison and I will try to offer perspectives from both defense and coverage counsel in dealing with these types of demands. We recognize this CLE is being held in the early afternoon after lunch, and I know folks may be a little tired, and we'll try to make it as exciting and enjoyable as possible. And we do hope, though, that this will be interactive as best as possible, given the remote nature of this CLE. But we do encourage folks to ask questions as we go. All right. Policy limit demand. First off, what is that? It's a settlement demand to the insured's carrier to pay the limits of any available insurance policy. This can be made at any point during the litigation process, including pre-litigation through trial. So what is the purpose of a policy limit demand? Well, it can be a powerful tool used to reach a resolution in a case. A timely and well-executed policy limit demand can settle a case for most that the plaintiff could ever practically realize. It is often a source of headaches for those at the insurance company. It forces the insurance company to consider a settlement. If the carrier doesn't accept, the insurance company could be obligated, under certain circumstances, to pay the entire verdict, even if that number exceeds the defendant's policy limits because the insurer failed to settle the case within limits when it had the chance. This is a tool that the plaintiff and their attorney have in their toolbox and get to decide when and if to use. So what happens when the offer is accepted? Well, it settles the claim and provides closure to the parties. Like with any settlement that happens, both parties avoid the inherent risks and uncertainty that comes with litigation. The parties, as opposed to a judge or jury, get to make the determination on the outcome of the claim. Both parties also avoid the expense and stress with further litigation. The plaintiff's recovery is also accelerated in most situations. Depending on what stage the claim is in, the plaintiff may not need to go through a lengthy legal process in order to recover. This certainly provides an incentive for a plaintiff to resolve a case potentially less than the initial policy limits demand that has been made. The insured also benefits from reaching a resolution because their personal assets are no longer potentially exposed. The settlement cuts this risk off. But if the carrier rejects the demand, the insured could be personally exposed if things go horribly wrong at trial and the verdict exceeds the limits of the available insurance policy. It's certainly within the insured's best interest to attempt to resolve the case within policy limits and avoid an excess judgment if that's possible. As I mentioned a moment ago, under certain circumstances, if the carrier rejects the demand, it could lead to the insurance company having to pay a verdict in excess of the policy limits. JAMISON will cover this a bit more in a few minutes, but as the slide in front of you shows, a liability insurer must act reasonably to settle a claim for within the available policy limits. The carrier, again, may be liable for any excess verdict if the insurer did not reasonably attempt to settle the claim within the policy limits when it had the chance. As you can see on this slide, I've got a citation to Goddard versus Farmers. Although Goddard is not a policy limits demand case, I believe, it still stands for the proposition that the insurer has an obligation to attempt to reasonably settle the case within limits when it has an opportunity. And the issuance of a policy limits demand could trigger that obligation for the carrier to try to settle it. All right, let's talk about defense counsel's role. In the next several slides, I'm going to cover defense counsel's role in dealing with a policy limits demand. As insurance retained defense counsel, you have obligations to both the insurance company and the insured you've been hired to represent. If you've not been retained by insurance, your obligations are to the insured, who is your sole and only client, not the insurance company. These are important distinctions, as the slides we're about to cover will note, for how you go about handling a policy limit demand. All right, once you receive the policy limits demand as insurance retained counsel, you want to make sure to promptly forward it to the claims handler. You might not be able to fire this off right away when you receive the demand, but you should send it off as soon as you're able to do so. Remember, you have an ethical obligation under RPC 1.4 to keep the client reasonably informed about the status of a matter. This includes notifying the client of receiving a settlement demand. I'm sure, as many of you know, Oregon's a tripartite relationship state. This means that when you've been retained by an insurance company, your clients are both the insured and the insurance company. As insurance retained defense counsel, you owe ethical obligations to the carrier and to the insured. Also, oftentimes a policy limits demand will come with a deadline. In most instances, these are artificially created by the plaintiff's counsel. If that demand does come with a deadline, make sure to point that out to the adjuster when you send in the demand and report it. I would suggest forwarding the demand in writing and saving that communication in your file to document that you've saved it. I even go so far as to calendar the deadline, and will follow up with the carrier a few days before it expires if I haven't heard anything yet. So the next slide will discuss what sort of information you want to pass along to the insurance company when you do report receiving that policy limits demand. And depending on what stage the case is at, you might need to complete a settlement evaluation or update your prior evaluation. As JAMISON is going to get into a little bit more later, this information is needed for the carrier to have in its file as part of its obligation to investigate and evaluate the claim. So if you're not able to provide this evaluation right away, still promptly forward the demand onto the carrier and let the claims handler know that your evaluation and recommendation will follow. It may be that you've provided a recent settlement evaluation, given where the status of the case is at. That's fine. Just ask the adjuster whether they need you to update that prior evaluation. It could be that the demand came with new information that might impact your prior evaluation in some way. And let's talk about your settlement evaluation. As insurance retained counsel, your goal is to provide an objective evaluation of the demand. This is going to cover the likely topics of your analysis of the liability and damages issues in the case. You also want to provide a reasoned settlement recommendation to the carrier. If you believe that the case is defendable and the damages have been overstated by the plaintiff, you might not recommend accepting the policy limits demand and suggest something lower. Conversely, it may be that recommending the carrier accept the policy limits demand is consistent with your settlement evaluation. Again, your goal here is to provide an objective evaluation of the demand and a reasoned settlement recommendation. Sometimes you might be at a stage in the litigation process where you don't have all the information just yet to provide a comprehensive settlement evaluation. I know I've been there, and I'm sure others have as well. What I try to do is provide what evaluation I can, and then tell the carrier what additional information is needed and why. Could be that you don't have information that you need to properly evaluate that demand because you're missing plaintiff's damages information. Because the demand may have come at a point when you're not yet in litigation, or discovery has only recently commenced and you don't yet have that documentation. Again, you can still provide your evaluation to the carrier and just let them know what limitations you're having in providing that evaluation and what additional information is needed to complete it. If there's a deadline on the demand, suggest to the carrier that you request an extension to respond from plaintiff's counsel. This might be a good time to have a conversation with plaintiff's counsel about the information that is needed in order to properly evaluate the demand. This could streamline discovery efforts, getting you that information you need to complete your evaluation, which could also result in a favorable resolution for you and your clients. Next, you also want to advise the insured of the demand. Copy them on the communication to the carrier. This is also part of your ethical obligation under RPC 1.4 to keep the client informed of developments. Also, some insurance policies, like those covering professionals, require the insured to consent to settlement. And this is another reason why an insured needs to be kept abreast of a policy limits demand, as well as receiving your evaluation of it and settlement recommendation, so that they may make an informed decision as to consenting to that demand. If your insurance retained counsel, it's a great idea to recommend to the insured that they have outside counsel involved. There's ethical limitations that can arise as in your role as insurance retained counsel, and you should explain some of those limitations to the insured. And those are limitations that can justify the insured retaining private counsel and having them involved in this process. The primary way I see this come up is when the insurance company has raised coverage issues, whether that was done through a reservation of rights letter or a DEC action to determine coverage. As insurance counsel, you're prohibited from getting involved in coverage-related issues. As we all know, this is a conflict of interest, as it would require potentially putting the interest of one client ahead of the other. So if coverage issues have been raised by the carrier, the insured should have separate counsel, and I would make this recommendation to the insured to retain separate private counsel to address those issues. That attorney can make arguments to the carrier and protect the insured's rights in ways that you can't do as insurance retained counsel. Also, it's really important to note here that it's not your role as insurance defense counsel to advocate a settlement position to the carrier on behalf of the insured. Your role is to provide a reasoned, objective settlement evaluation and recommendation. If the insured has a settlement position, you certainly should pass that information on to the carrier. For example, you can say something like the insured has expressed an interest in resolving the case for policy limits. Still provide your objective settlement evaluation of the demand, which may or may not support paying the limits.
Hey, Peter.
Yes.
Looks like we got a question, so I thought
Great.
I'd toss it out there. This is from Eric Meyer. He said, if you tell the carrier you don't believe the case to have value equal to or greater than policy limits, and then you get an excess verdict, does this compromise your ability to advocate for your client with the carrier in demanding that it cover the excess if the court is not satisfied that a reasonable effort at settlement was made by the carrier?
I think it's a great question. I think it's a great question too for coverage counsel. Way to pass the buck.
No, I think that's fair. So Eric, if I understand your question, this is kind of different doing it by the chat function because, if we were at the actual convention, I could, field this or, people can comment on it. But if I understand your question, you're asking if you tell the carrier, what you think the value will be, and then the jury returns an award that's different than that or higher than that, does this compromise your ability to advocate for your client and getting the carrier to cover the difference between the policy and the excess? And I would frankly hope that I would never have to be in that position. I think that raises some tough questions in regard to that tripartite relationship. I would frankly, if that's the case, I would have the insureds counsel make that pitch to the carrier. Peter, I don't know what your thoughts are, but if I'm defense counsel, I don't want to get anywhere in the middle of that.
Oh, I agree wholeheartedly. And I'm not sure that you could get in the middle of that. You're really venturing into, the conflict area that the insured needs to have their personal counsel involved. Yeah.
But
great question.
I think Eric, though, is, raising a good point, which without, previewing my presentation too much, that is one of the tools that a carrier can have. If there's a claim that the carrier truly does not think is an excess case, they can enter into an agreement with the insured to cover the difference if things go south at trial. So I think that's an excellent point, Eric, but it definitely gets sticky with the three parties involved.
Absolutely agree. So again, the insured's personal counsel, it's important to recommend to the insured that they have that personal counsel, whether that's a company that's got in-house counsel or their outside corporate counsel involved, to advocate a settlement position on behalf of the insured if that approach is necessary after receiving that policy limit demand. And so if you are representing a sophisticated client, they may already have separate counsel who can take on this role. I would recommend trying to figure this out early on in the process, whether they do have in-house counsel or outside counsel. And it's probably a good idea if they do to keep that attorney copied on reports to the carrier so that they're aware of case development. So when and if you get a policy limits demand in, they're not playing catch up and can address whatever issues you are conflicted from handling more efficiently and smoothly for the insured. So once you receive settlement authority from the carrier, make sure that you promptly convey that offer to plaintiff's counsel. This is another area where I would recommend that you document in writing the offer that was made. If the offer was extended by phone, follow up with a letter or email afterwards. This memorializes what was offered, so there is no dispute later about the terms of the offer that was made. Also, consistent with RPC 1.4, keep the carrier updated on the status of developments. My practice is to report to the claims handler once the offer has been made, especially if there's a deadline attached to the demand. If settlement discussions continue, again, keep communicating these developments to the carrier and the insured in a prompt, reasonable manner. I'm now going to turn it over to JAMISON to talk about coverage counsel's role.
Thank you, Peter. So Peter's presentation tended to focus on best practices when you've been retained by an insurance company to defend its insured. So I'm going to talk about policy limits demands from a slightly different perspective, and that is the perspective of coverage counsel, who is evaluating and making recommendations to the insurance company. So for coverage counsel's role, I mean, I thought I would start out by just introducing this carrier's duty to settle and where it comes from. You know, I work with Rick Lee, who likes to always talk with his hands. And so the two big, you know, duties we talk about in the insurance context are the duty to defend and then the duty to indemnify. So where this duty to settle comes in is not necessarily something we talk about, I feel like, as much as the other two, the two duties. I mean, whether a insurance company has a duty to defend its insured in a lawsuit, or whether an insurance company has a duty to pay a settlement or pay a judgment. So the duty to settle is actually a subset of the duty to defend. So when an insurance company takes on the defense of its insured, it has a duty to exercise that defense with reasonable care. And the courts describe this as a fiduciary duty. So as attorneys, or as, you know, Peter in his role as defense counsel, I mean, he certainly owes fiduciary duties to both the insurance company and the insured. But once the insurance company takes on that defense, it also owes separate fiduciary duties to the insured. And the reason for that is by tendering defense of the claim to the insurance company, the insured has in many respects relinquished his or her control over that claim. Many policies, for example, give an insurer the right to settle a claim at its own discretion. The insurer has the right to retain defense counsel of its choice. In many respects, it has the right to direct the course of the litigation and how it's conducted. So with those benefits that the insurance company has in defending the case, it also has some burden. And so it has an obligation to exercise due care to its insured when conducting the defense. The insured is basically, you know, putting their fate, so to speak, in the insurance company's hands. And so the insurer has to take that duty seriously and cannot take it lightly. In addition, the Oregon Insurance Code requires insurance companies to affirmatively explore settlement. You know, an insurer can't just wait for the plaintiff to make an offer, and if no offer comes in, just say, well, you know, hey, we didn't have an opportunity to settle this case. An insurer has a duty to not only work the case up towards trial, but also to work it up with an eye towards settlement. And the specific statutory provision is ORS 746230, which makes it an unlawful practice to not attempt in good faith to promptly and equitably settle claims in which liability has become reasonably clear. So, you know, in advising an insurer, you want to advise them to proactively look towards opportunities to settle a case, preferably before a policy limits demand comes in. So we talked about how the insurer has a duty to settle. So I want to unpack that a little bit as far as what the applicable standard of care is for the insurer in handling the duty to defend and the duty to settle. And the standard is, it's an objective test. It's what an ordinarily prudent insurer with no policy limit applicable to the claim would be. So often we talk in terms of good faith or bad faith, and the Oregon Supreme Court has expressly rejected that nomenclature because it tends to interject a subjective element into the analysis. And it's really, is the carrier acting reasonably with its duty to settle? If a carrier is not acting reasonably, it could face potential liability for an excess verdict or an adverse result that occurs to the insured as a result of its breach. So in order for an insurer to be found negligent or to be found to have not exercised reasonable care, really two elements have to be met with respect to the duty to settle. The first one is there a reasonable opportunity for settlement? And a policy limits demand can meet this element in certain circumstances. Certainly in some circumstances, it's reasonable for a carrier to pay a policy limits demand, but that's certainly not the case in every case. And there are certainly cases where paying a policy limits demand would be unreasonable for a number of reasons. Second, an insurer can be found liable for breaching the duty to settle if, in choosing not to settle, it's taking an unreasonable risk to the insured. And so, unfortunately, there really aren't any bright line rules on what is reasonable and what is unreasonable. There are certainly some cases where courts have found that certain conduct by an insurer was unreasonable, but reasonableness, I mean, it has to be determined on a case-by-case basis, depending on not only the claim that's presented, but the specific facts and circumstances of that case. So as an insurer, when advising insurers, you want to make sure that they're exercising due care, acting reasonably in that specific case based on the information that's presented. So some factors for an insurer to consider when it receives a policy limits demand is first and foremost the reasonableness of the demand. And that's determined by a number of factors. If you have excellent defense counsel on board like PEDER, I mean, this should be a pretty easy job for the insurance company. Has liability been determined? Is this a case of clear liability or are there liability defenses? Is there a comparative fault? That would be one of the first steps. The second step would be to analyze what are the plaintiff's damages. Is this a straightforward whiplash case where the plaintiff treated for a couple weeks and then was discharged? Or is this a case where someone was catastrophically injured? The next step then is to analyze what the potential outcomes are at trial. And this includes not only analyzing what is the most likely outcome, but also what are the chances of an adverse result if for whatever reason the jury does not see things our way and could very well return a large damages award. What are the chances of that? Which again is based on not only the information the defense counsel has provided, but also your evaluation as coverage counsel of the case. The next question is, what is the potential risk of there being an excess situation? is this a case where the plaintiff's medical bills are $10,000 and they're alleging $900,000 in non-economic damages? We've all seen those types of cases. So again, it's just really evaluating the claim that's being presented and what is most likely going to happen at trial. I mean, what do we think a jury's going to do? What are the likely verdict scenarios? What could happen, and what are the chances of it? The third kind of factor I've identified is opportunity to investigate and the information that's provided. As Peter mentioned, these policy limits demands, they can occur at any time. They can occur during the lawsuit. They can occur pre-suit. Sometimes discovery is complete. Sometimes this is the first notice of a claim. So when advising a carrier, it's important to advise the carrier to consider and identify what information they need to make an informed decision regarding the policy limits demand. In litigation, this is pretty easy for a carrier to do because defense counsel has tools at their disposal which they can use to get information to evaluate the claim. They can serve discovery requests, they can take depositions. If plaintiff's counsel for one reason or another has not produced records, defense counsel can subpoena those records. Those are all tools that defense counsel has in their toolkit to evaluate the claim. It certainly gets a little trickier when a claim is pre-suit because a carrier who receives a policy limits demand doesn't necessarily have those tools at their disposal. So if additional information is needed from the plaintiff and this isn't something that defense counsel has access to, I recommend that the carrier follow up with the plaintiff's attorney in writing and identify what information they need, why they need it, as well as an estimate of how long they would request for time to review this information. And then after doing so, identify and conduct any additional investigation that needs to be conducted, whether that's interviewing the insured, going out and interviewing non-party witnesses. It's important that the carrier have enough information to make an informed decision about the claim. If an investigation for one reason or another cannot be conducted within the deadline set forth in the policy limits demand, it's perfectly reasonable to, again, in writing, request from the plaintiff's attorney more time to investigate or consider the demand. Most plaintiff's attorneys, in my experience, and Peter, I'd be curious to hear your thoughts on this, but I feel like the plaintiff's attorneys who are experienced and they know what they're doing with these demands, if you ask for a reasonable extension of time, they'll give it to you.
Yeah, I agree, Jamison. My experience has been the same. And although I will say, I think you have better luck, or at least I have better luck when I say I need X, I need medical records, or I need, if it's a construction case, right, I need your scope of repair and your cost estimate before I can, evaluate the demand. I think, if you can provide those explanations why you need this additional information or this additional time, the justification for it, I think most plaintiff's attorneys will work with you. Obviously, there's those folks out there that try to use the policy limit demand to attain some sort of legal advantage and to try to get it an excess verdict, and they're not willing to give you extra time because they frankly don't care.
Right. And I think when they do that, they are frankly undercutting their potential excess case that they're trying to create. Because again, a carrier has to have a reasonable opportunity to settle. If a plaintiff's attorney fires off a demand, won't give you any information, won't give you any opportunity for additional time, and there's really no valid reason for them to enforce that time limit except to, hold your feet to the fire. Again, that's going to be that's going to kind of undercut the argument that the carrier was not acting reasonably, especially if as soon as they receive the demand, they immediately follow up in writing and request additional information. And like Peter said, specifically identifying not only what they want, but why they need it. So, the saying I've heard is an experienced plaintiff's attorney will try to give the carrier enough rope to essentially hang themselves, which is kind of a morbid saying, but I think it suggests that a plaintiff's attorney who's really trying to put pressure on the carrier will actually give that additional time, so that way the carrier feels like they've had an opportunity to do their due diligence. Other factors to consider, Peter mentioned this in regard to specific policy terms. Is this a policy that requires the consent of the insured to enter into the settlement agreement? Certainly if a carrier receives a policy limits demand, but the insured says, they have the right to say no, and they say, hell no, I don't want to pay that person a dime. That's something that needs to be addressed and considered in the carrier's decision-making process. And again, to the extent that comes up, this will be kind of a common theme in my presentation, is just, again, follow up with the insured in writing regarding their position as well as the carrier's position. Sometimes a policy limits demand cannot be accepted because it requires an action by a third party. So what can happen, or often does happen in cases, is an insured is defended by multiple insurance carriers for a claim, and a plaintiff will fire off a policy limits demand saying, I want all available limits for all policies. That frankly kind of puts the carrier in a tricky situation, because there's a chance that the plaintiff may not accept just their policy limits if they offer it. With that said, if there is another carrier involved, your client or the insurer you're advising, they can't just wash their hands of the policy limits demand and say, well, look, they asked for both policies. This other carrier wouldn't do it, so there was an opportunity to settle. It's important that you proactively and that the carrier proactively try to look for other opportunities to settle. And for example, if there's a carrier who's not participating or not holding up their end of the bargain, maybe a better approach might be to enter into a settlement with the plaintiff and then, perhaps sue that non-participating carrier for contribution. One final takeaway is, there's also the potential for multiple claims. You can certainly see this in an auto accident where, let's say there's 3 people in the car, they're each making a claim for damages. This again can put the carrier in a tight spot. So it's important that the carrier is taking steps to, as best it can in that situation, to make sure that the insured is protected. It's not just tendering its limits and then just leaving the insured open to additional claims. So again, no bright line rule. It just has to be evaluated on a case-by-case basis, depending on what's presented. Unfortunately, advising carriers gets especially tricky when there is a reservation of rights that was issued by the carrier and there's a policy limits demand pending. So for example, let's say there's a claim for $1 million. A carrier has picked up the defense, but only 10% of it is covered. The question becomes then, what are the carrier's obligations in that instance where there's a sizable claim, but very limited coverage? And admittedly, I have to say my opinion as a case law is not entirely clear on that. I presented two cases, Safeco and Northwest Pump. Northwest Pump essentially stands for the proposition that the insured should not get more than they bargained for. They paid for a policy. The policy is subject to certain terms and conditions. So in that instance, the insured should not, essentially get a windfall with coverage. On the other hand, you have the Safeco case, which is an interesting case. It was a personal injury claim. The insured tendered the matter to Safeco. Safeco accepted the tender of defense, and the case proceeded to trial. A judgment was returned against the insured. Safeco then initiated a declaratory judgment action saying, look, we don't have any obligation to pay this judgment. And the insured filed a counterclaim against Safeco saying Safeco had breached its fiduciary duty by not trying to settle the claim before the judgment was returned against the insured. Remarkably, the court started its analysis by finding that Safeco, in fact, did not have a duty to defend the claim. But because it had undertaken the defense of the insured, it still had a duty to try to settle the claim, and it still owed the insured those fiduciary duties, even if there originally was no duty to defend, and it undertook its defense by mistake. So, I mean, where you find yourself on the spectrum between those two cases, I think depends on a case-by-case basis. I think one of the best things you can do as coverage counsel is try to educate your clients early on regarding this distinction that the duty to settle is there's a duty to try and settle the claim, even if there is no duty to indemnify or no ultimate duty to pay a judgment. I think that, getting your client on board with that concept early can help, but I think you're still facing the issue of, for example, if you have, $1 million claim and only 10% of it's covered, that still puts the carrier in a tight spot. So in the event that the carrier has to deny the tender or deny the policy limits demand, I just kind of want to talk about best practices for that. Obviously, in the first scenario, if the carrier accepts the policy limits demand, it's pretty straightforward. The parties prepare a release. The carrier issues a settlement check. The parties dismiss the case. Everyone moves on their way. If an insurer rejects a policy limits demand, it has to go through some additional steps to make sure not only that it's, one, fulfilling its obligations to its insured, complying with the law, but two, making sure that it's taking steps to protect itself from claims down the road that it was not acting reasonably in its defense of the insured. So these are kind of like what I would call the bare minimum things to do. Number one is make sure that the insured has been notified of the policy limits demand, as well as the insurer's decision to deny coverage. This sounds crazy, but there's reported cases where insurance defense counsel received a certain type of demand, either during trial or elsewhere and then never notify the insured of it. That's obviously a big no-no, as Peter's talked about in his presentation. Number two, make sure that the carrier responds to the policy limits demand within a reasonable time, preferably within the time period stated in the demand. Even if the carrier is just simply rejecting the demand, it's important to do that in writing so it's documented, everyone's on the same page, everything's above board. I also recommend that insurers make sure to document their investigation and evaluation of the claim. If they're denying a policy limits demand, state the reasons why they're denying it, what went into that decision, why it was not a reasonable opportunity to settle a case, and why the insurer is exercising reasonable care by not doing so. And then if the policy limits demand is rejected, as we know, the insurer is not off the hook. They can't just say, well, we rejected it. That's the end of the story. As we've talked about, they have a proactive duty to look for opportunities to settle the claim, continue to evaluate the claim for resolution through trial. And, you know, I think perhaps a good example of this is, I'm sure some of us have been in the situation where a claim doesn't look like it's going to settle. We do jury selection, opening statements, and boom, there's a settlement offer from the plaintiff. That's great. It's important that if that opportunity presents itself, that the carrier is in a position or is prepared to take advantage of that opportunity, or at least continue to evaluate it. On the other hand, we pride ourselves here in Oregon on being a trial by ambush state with no expert discovery. There's a very real chance that even if I provided an evaluation to the client about what I anticipate the plaintiff is going to present at trial, the experts they present could be remarkably different than what I initially anticipated. So again, I advise a carrier to make sure that they remain available during trial to the extent that trial testimony comes out differently than I think it's going to come out. I can promptly get a hold of my client and we can certainly reevaluate for resolution. I really like this slide. I mean, I think this kind of sums up the big picture of the advice to the insurer is just document what you're doing. There's a quote from our worthy opponent, Don Corson. His advice when writing policy limits demands to plaintiffs' attorneys is write all letters and emails as though they may become jury exhibits in a later trial because they might be. And I think that's a good quote because for a number of reasons. First, I mean, I think we all kind of know that's the intent of these policy limits demands is to try to put pressure on the carrier to settle. But it doesn't have to be a one-way street where the plaintiff is going out and creating evidence with their well-written policy limits demands, which list all the bad facts about liability and all the bad facts about damages. An insurer can also create evidence themselves, which will help them down the road. And when I use the term create evidence, I'm obviously not encouraging people to fabricate evidence, but how you respond to the plaintiff, how you respond to the insured, how well the claims file is maintained, how well the reasoning is in the claims file, that could all be evidence in a subsequent excess case, which the insurer can then use to bolster their defenses. I mean, what you don't want to see is you don't want to see a policy limits demand in the file, and then there's no analysis of it and no response to it. I mean, if an excess verdict comes down, you can certainly still defend it, but it's going to be based on testimony as opposed to what's written. I think Mr. Corson's quote is a good one. I'm perhaps a little bit more crass. I would just say, I expect the letters that are exchanged to be blown up in front of the jury on poster board. That's going to be Exhibit 1A. So, are you going to want to look like you're not giving this much thought? Or on the other hand, the carrier, are they going to want to look like they're bending over backwards to protect their insured, but they just don't have a reasonable opportunity to settle this case for one reason or another? I have a couple more topics. Looks like we got about 5 more minutes to go, so I'll just try to cruise through this a little bit. Stipulated judgments, just real briefly, that's another risk that coverage counsel needs to advise their insurers on about the risk of. If for whatever reason there's a breakdown in the tripartite relationship, one tool that the insured has at their disposal is they can enter into a settlement agreement with the plaintiff for a set amount. And the statute ORS 31825 expressly allows them to do that. The insured enters into a judgment. If that judgment's not satisfied within a set period of time, the insured can then assign their rights against the insurance company to the plaintiff in exchange for a promise by the plaintiff not to execute on that judgment. This might be advantageous to an insured. They may not care if they have a judgment against them, just as long as they don't have to pay any money out of pocket. Typically most policies contain provisions requiring either the cooperation of the insured, the consent of the insurer before a settlement's entered into. And courts typically, when enforcing those provisions, what they look at is whether the insured acted reasonably. And so again, those best practices we talked about in, communicating with the insured, making sure that communications are in writing, the insured's being apprised of what's going on. Those can all go into, again, evidence of whether the insured acted reasonably by choosing to enter into a settlement on their own without the consent of the carrier. Just real briefly on garnishment. Garnishment it's not really an excess issue. There's case law which says that a plaintiff cannot garnish against a policy for an excess case. It's really just another method for determining a carrier's insurance obligations after an insured becomes liable for damages, either through a judgment against the insured or through a stipulated judgment. Found court case is a good explanation of that, as well as Hunter's Ridge. It looks like we have about 2 minutes left, so I thought I would just open this up for questions if there are any. But otherwise, it's been a pleasure to present to this group, especially under the circumstances. So.
Well, I'm not seeing any questions pop up on the chat board. So Jamison, Peter, thanks so much for the presentation and the discussion about how to approach these sensitive issues. Thanks for taking the time to present this here today.
Thank you for listening.
Brian. Appreciate it.
And to the rest of you out there, this is a reminder that you'll get an email following today's presentation with instructions on how to obtain CLE credit. Our 2020 virtual fall seminar will continue tomorrow at noon. Our two presentations tomorrow are Damage Control featuring Aaron Foote Morgan from Hubble Communications and Implicit Bias presented by Judge Adrian Nelson. Thanks, everybody, and enjoy the rest of your day.